Hey, gun people, here we go. Part 4, officer safety. Oh, I love to hear that term. You always know shit's going to get deep and diluted when you hear that. How do we end this here? You're free to leave. The officer used commanding tone of voice. The officer kept leaning over and resting his arms on the driver's door. Okay, so that's why they said when free to leave didn't work on that one. All right, number 4, officer safety measures. What the hell we're going to talk about here? It's a pretty short one. A suspect who has been contacted may, of course, pose a threat to the officer. Ooh, officer safety. I felt fear in my life. This can create a problem because many officer safety precautions send the message that the suspect is being detained. Ooh, it's going to get good. For example, and not surprisingly, the courts have ruled that a seizure will result if the officers drew their guns on the suspect. I agree with that. If a cop's pointing a gun at you saying you're free to go and you're not detained, I might question that. So, courts ruled pretty good on that one. If a cop points his gun at you, you're detained. That's pretty much been set in stone for decades. Let's see. If they drew their weapons on suspect, handcuffed him, or conducted a non-consensual pat search. So, according to this, if I pat you down, you're detained. Now, I'm not so sure on that. I've patted people down when I've given them a courtesy ride. And if I was arguing this in court for a cop or trying to get a cop to say, have you ever patted somebody down and didn't detain them? Absolutely. In one case in particular, in many cases, if I'm giving somebody a courtesy ride because their car broke down or they need a ride to the gas station or something, I will put them in my car. And policy says anybody I put in my car, I'm required to pat them down. So I pat them down, even though I'm doing this voluntarily, and they ask me for a ride, and they know that a condition of me giving them a ride that they want requires me to pat them down. And it was not a detention. So, no offense, Mr. Court, Your Honor, but you're wrong if you say if you pat somebody down, they're detained. That's bullshit. But I'm sure, again, totality of circumstances. Let's see. Still, some precautions are permitted because they are relatively non-intrusive. Backup officers. The number of backup officers there, proximate to the suspect. Again, whether there's 2, 4, 6, 8, whatever, circling and backing them in the corner. To the suspect, and a manner in which they arrived, conduct themselves are all relevant. That's key. If it's relevant to the court, does that mean a cop has to put in a report? Raise your hand if you think a cop has to put in a report how many officers are there because it's relevant for the court to figure out. Raise your hand. You big dummy. Cops aren't required to put that in a report. Cops aren't really required to put any damn thing in a report other than who, what, when, where, and why. I mean, even then, cops screw that shit up and can't get that. I mean, sometimes you want to get how in there, but look, just because the court said we need to know that, if the cops didn't document it and it's not on any videotape, the court can do one of two things. They can say, we believe the officers and rule with the officers, or they can say, because you didn't put it in report and because there's no other evidence, we're going to rule against you. Me personally, I think it ought to be the latter. I think if you don't document and prove it in a report, then the court ought to rule against you. Default ought to be, if you don't do your job, government paid employee, cop, officer, making money, retirement, benefits, etc., if you can't do your freaking job, you lose. No ifs, ands, buts, or coconuts. Done. That's pretty freaking easy to me. But government doesn't like losing, and they like to protect government. So they come up with these little ways to kind of justify how we can help government. Let's see. The number of backup officers. For example, in U.S. v. Washington. Washington, not the state, the person. Probably first name Tyrone. The court ruled that the defendant was seized mainly because he was confronted by 6 officers who were around him. If 6 cops are talking to you, you're probably detained. But Rick, I went to the policeman's ball and there were 50 cops there and I wasn't detained. Well, you're right. And that would be called the exception, not the rule. But normally, for most pesky citizens running around minding their own freaking business, when 6 cops get around you, you're detained. Unless you just want to try and run and test it. I mean, if you run and they tackle you, then for sure you're detained. Let's see, 6 officers. Similarly, in U.S., Buckingham. I think we already heard this, huh? Buckhammon. The court ruled the defendant was detained because, among other things, the number of officers that arrived. 3, the swiftness with which they arrived. Like Superman, they flew from their cars with their capes and arrived swiftly. And the manner in which they arrived, all with pursuit lights flashing. In contrast, the court have ruled that the detention did not result merely because backup officers were posted in the background, were out of sight. Okay, so in contrast, what they're saying is, in another case, the court ruled that a detention did not result because the officers were in the background, they were out of sight, and they were 4 or 5 feet away, and there was little more than passive observers. So, passive observers. That's a good definition of what cops do when they're out there bullshitting, checking their phone, sitting in the car. They're passive observers. So they're less threatening. So you can't claim that I was intimidated. Whereas when they're actively staring, circling, running, doing other things. I mean, hopefully you guys, at the end of this, if you watch it all, have a much better idea on what constitutes a person's mind as reasonable when he feels he's detained, and when the court going to rule, no, that feeling wasn't reasonable. Let's see. Remove hands from your pocket. Ooh, that's kind of iffy. I wonder how they're going to go on this. Has noted, a detention will not result if officer simply requests that the suspect remove hands from his pockets or keep them in sight. Now, they kind of gave you an isolated facts. Who can think of a situation where I ask you to take your hands out and it is a detention? But Rick, the court just ruled it's not. Well, I'm telling you it is a detention. If I tell you, take your hands out of your pockets and my gun's out and I'm pointing it at you, it's a detention. But Rick, you added the gun part. Well, no shit. That's where totality of circumstances come in, you big dummy. Let's see. Has the Ninth Circus observed police officers routinely ask individuals to keep their hands out of sight for officer protection. And here the request does not appear to have been made in a threatening manner. In this case, it was not made in threatening. Again, it is important that the officer requested. See, this is where cops get confused. Oh, as long as it's a request, I'm good to go. No, it isn't. The officer requested and did not command. That's one incident in the totality of circumstances that could or could not be true, depending on what you add in the totality of circumstances. The suspect to remove his hands, as the Court of Appeals explained. The manner in which the request was made constituted a show of authority such that the appellant reasonably might believe that he had to comply. Then the encounter was transformed into a detention. Why was it made a detention? Because a reasonable person believed he had to comply. When you lose the ability to freely leave and freely act, you're detained. Which one could argue, if you don't let me put my hands in my pocket. If I can't put my hands in my pocket, I'm leaving because it's cold out. And if you're going to make me stand here with my hands out, I don't want to talk to you. Bye. Wait a minute, you can't leave. Then I'm detained. Perfect. Getting the message here? Then the encounter transferred into detention. For example, U.S. v. Jones, the court ruled that the detention resulted when the officers quickly approached Jones and nearly immediately asked first that he lift his shirt and then that he consent to a pat-down. Man, I don't know. I'd have to know more about that one. Just because I went up to him and go, yo, dude, lift your shirt up for me. He didn't have to. He could say no. Why? He didn't have to lift his shirt up. He voluntarily lifted his shirt up. And the cops voluntarily asked him, hey, man, do you consent for a pat-down? I'm not sure I agree that that's a detention. Of course, my opinion don't matter, but my argument would be, where did the officers exercise command authority? Were they screaming? Were they pointing guns at him? If they weren't, the suspect voluntarily lifted his shirt. And the courts have ruled in many occasions that I can ask anybody anything. I can ask you to take your hat off. That's not a detention. I can ask you to remove your sunglasses. That's not a detention. If you're still free to go and we're talking, hey, man, what time is it? Oh, it's like 4:30. Hey, man, would you mind removing your sunglasses? Kind of creating a dare. Okay, no problem. Took his sunglasses off. Is that a detention? No. So why, if I ask him to raise his shirt, is it a detention? I don't know if I agree with that one. Rick, you think you're smarter than the court. Yeah, actually, I think I am smarter than a lot of courts when it comes to common sense. But the court rules on past ignorant judges making past ignorant rulings, and that becomes case law, and then we end up making rulings on that, and then next thing you know, people think that's normal, they ignore the Constitution, and it becomes, that's the way we do business, normal course in action. Warrant checks. Running a warrant check without the suspect consent will not result in detention. I agree. But it can be problematic because it takes time to get the information. And as time progresses, the suspect might reasonably believe he is not free to leave. So, if I run you for a warrant and you go, am I detained? And I've done this many times. Yo, man, isn't your name Johnson? Yeah. You got an ID? Yeah, here you go. Okay, give me all systems on one, give me all around on one, however you call out your 29s on one, however you call out for cops when they call out wants and warrants. So I give his name and date of birth, the thing, I give him his ID back, and I go, okay, thanks a lot. He goes, hey, man, am I free to go? I go, yeah, I was just going to talk to you. You got any warrants? No. You on probation parole? No. Hey, man, am I free to go? I told you you're free to go, dude. I'm just trying to figure out what's going on. I'm bored. It's late. You're out here, freaking high crime area. I'm trying to protect you. You're not a victim of a crime. I'm trying to protect and serve. Are you okay? Yo, man, you're being an asshole. Dude, all I'm trying... I can talk all freaking night as long as he stands there and talk if I keep telling him he can leave. And what happens when he walks away? I say, see you later. Have a good night. I sit in my car and I drive behind him. And I follow him until the warrant check comes back. Rick, you can't follow him. You don't have probable cause. I don't need probable cause or suspicion to follow him. I can follow him all day long. He's in a public area. So I follow him. When the warrants come back clear, I drive away. When they come back, he's got a warrant. I activate my overhead lights, get on the PA and go, dude, you got a warrant. Stop walking. And then he takes off running and I call in pursuit. And that's how it usually goes down. All right, here we go. Requesting ID. Before attempting to confirm or dispel their suspicions, officers will usually ask the suspect to identify himself, preferably with a driver's license or other official document. Like a request to stop, a request for ID will not convert a contact into a detention. Man, I don't know about that. If you're asking me for ID, but I go back to, you can ask, I don't have to give it to you. I can say, I don't want to answer questions, I'm leaving. I can make the cop say, you can't leave. You have to give me ID. Great. I'm detained. You're giving me orders. Now anything you find is going to be expressed unless you can tell me how you why you have to articulate suspicion and belief that I'm here. Now the cop doesn't necessarily have to tell you. You may not know that there was a robbery and a guy had the same shirt you had on or the same sneakers you had on or whatever. So it may be a lawful detention. You just may not know it. But you still always want to force the cop's hands to say, you're not free to leave. You're detained or you're under arrest. As soon as you can get that, then we don't have to play this game. Can I leave? Is it okay for me? Do I really have to answer that? I'm not sure I feel comfortable with this. Do I have to give ID? In Texas, it says I don't have to give ID unless I'm suspected of a crime. And according to this section, blah, 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 you're asking me and I'm not suspected of a crime. What crime do you suspect me of? Now you get into a conversation. You're allowing contact and exchange with the officer, and it's stupid. I'm leaving. Goodbye. Unless you tell me I can't, see you, wouldn't want to be you. Go have another donut on me. I mean, just leave, people. All right. Where the hell was I? Let's see. Like press to stop running. As the Supreme Court explained, no seizure occurs when an officer asks to examine an individual identification, so long as the officer does not convey in the message that compliance for their request is required. The courts just gave you the answer. As long as you volunteer to interact with police, you have no protections. You only have protections against unlawful detention when you shut up and leave, and you make the officer say, you can't leave. Stop. Give me your ID or I'm going to arrest you. Get over here and sit on the curb. You make the officer do that, and then it's clear to everybody you're detained, and you don't have all this if, and, buts, and coconut shit in the courtroom, and they end up ruling for the officer. Let's see. The tricky thing about requesting ID is that the detention may result if the officers retain the ID. Very true. If you give me your ID, and I've seen officers do this all the time, I'm going to hang on to it till your checks come back. That's a detention. If a guy gives you, first of all, the idiot shouldn't have gave you his freaking ID. But if he's dumb enough to give you his ID, maybe he's smart enough to say, can I have my ID back? And then you say, no, I'm keeping it till I run the check. You just detained him. Now he does not have the right to leave because no reasonable person is going to leave without their ID, that they have to go to fucking DMV, fucking another government agency that's incompetent and wait in a freaking line for 6 hours to get a new driver's license. So no reasonable person is going to give up their driver's license to a cop. So when you say you ain't giving it back, the people ain't leaving. They're detained. Let's see here. Ninth Circuit. When a law enforcement official retains control of a person's ID papers, such as a vehicle registration, documents of driver's license, longer than necessary to ascertain everything is in order. Well, first of all, if he's getting all this, you're already detained. Unless you're a freaking idiot giving all this to an officer, you're detained. When a cop pulls you over and says, give me your registration papers, you're detained. There's no ifs, ands, buts, or coconuts on that shit. I don't know what the hell they're talking about. For example, the courts have ruled that a detention results when an officer held on to the ID while he conducted a consent search when the officer pinned the ID to his uniform. When you say pin ID, a lot of cops have a pin in their pocket. So a common place for cops so you don't forget the ID is you slide it underneath the clip that holds your pin. That's why it's right there on your chest, and usually the kind citizen will remind you to give him his license back and won't let you drive away, and you end up with freaking 10 licenses at the end of shift, and you're trying to mail them back, or everybody's calling a sergeant saying, hey man, a cop kept my license, and hey man, did you keep his license? And you got 10 of them. Yeah, what's his name, man? I got 10. So obviously you want to keep the license where you won't forget to give it back. So sticking it underneath the clip on your pin and your front of your shirt to where it's right out in the open is a good way to remember that. Then when I get in the car, I sit down and I see it, I'm like, oh shit, I still got his license. Let me give it back to him. Where are we? Shit. Request ID, convert contact. Tricky thing. Oh, I'm up top. I went to the other side. Sorry. Walk back. Officer took the ID while he walked back to patrol car to run the records check. That guy's detained. I don't need a freaking court to tell me that. The officer necessarily had to keep the license and registration for a short time in order to check it with the dispatcher. I don't give a shit. If I voluntarily give you something, I can ask it back, and you must give it back. Otherwise, it's not voluntary. If you say, hey, man, let me see your driver's license, and I hand it to you, and I immediately say, I want my driver's license back, and the cop goes, no, I'm not done looking at it. You're detained. You can't leave. He's got your license, and he already told you he's not giving it back. You're detained. But Rick, you didn't give him a chance, and if you gave it to him, you got to give him a chance. I don't have to give him shit. I didn't have to give him my license. If I give you my license, I can ask you back. If I tell you, hey man, you mind if I search your car? Sure, go ahead. As soon as you open the door, yo dude, I don't want you searching my car. Well, you already told me I could. Guess what? I just withdrew my consent. Remember, consent is voluntary, and if something you give it voluntary, you can take it back. If you can't take it back, it's not voluntary. Come on, people, keep up. Let's see. After engaged, the suspect taking appropriate safety measures, obtaining the suspect, the officers will ordinarily begin their investigation by asking questions, seeking consent to search, and complete field contact card. If I'm detaining you for any of that, you're detained. In this section, we will discuss how the courts determine whether the officer's actions in this phase would have caused a reasonable person in the suspect position to believe he is no longer free to leave. If you're getting all that from me, I ain't free to go. Or I'm a freaking idiot for giving you all that when I was free to go. In most cases, officers who have contacted a suspect will attempt to confirm or dispel their suspicion by asking questions. Correct, that's true. But the person doesn't have to answer. He doesn't have to stay there so I can ask him questions. He can ignore me and walk away. They forget to say that part. Has the court observed in People v. Manis, when circumstances demand immediate investigation by the police, the most useful and most available tool for such investigation in a general on-scene questioning? Well, that's reasonable. While questioning will not, per se, convert a contact into a seizure, you're getting pretty close. It can be problematic. That means you're getting pretty close. They say problematic, I say you're pretty close to detention. If the suspect gives answers that are vague, non-responsive, or unintelligible, meaning unintelligent, I'm not sure on that one. That is because such questioning may be lengthy, and the officer's manner may become so aggressive or accusatory that the suspect no longer feels free to terminate the encounter. Yeah, you're getting in a lot of muddy water here. But again, all that can be avoided by not answering questions and walking the hell away. Investigative versus accusatory questions. Now, without reading this section, who knows the difference between an investigative question and accusatory? Hey, man, what are you doing? Hey, dude, you just left that fucking house where they're selling drugs. Okay, they're the difference. You guys decide which one was investigative and which one was accusatory. Let's see. The courts distinguish between two types of questions, investigative and accusatory. While investigating questions are not likely to result in a detention, accusatory questions can do so instantly. Wow. Let's see what this one is. Has the Court of Appeal observed? Questions of sufficiently accusatory nature may, by themselves, be cause to view an encounter into a non-consensual detention. All detentions are non-consensual. Okay? You have a consensual encounter, but all detentions are non-consensual. By virtue, they're a detention. The cops are enacting government force and preventing your ability to leave. It's a detention. It's not consensual. Can you volunteer to be detained? You can. I gotta take a drink. Hang on. All right. Good iced tea there. I just made that. If y'all want some good tea, what the hell's the name of that tea that I get? Man, it is freaking great tea. I'll try to slide in a picture if I remember. I'll forget shit. Someone have to remind me in the comments. Let's see. Questions sufficient accusatory nature by themselves. The degree of suspicion expressed by the police is the important factor in determining whether consensual encounter has ripened into a detention. Ooh, we're ripening now. Ripening meaning we're getting more ready to burst the fruit of arrest. All right. For example, Florida versus Royer. The Supreme Court ruled that the contact in an airport became an illegal detention mainly because the officers informed the suspect that they were narcotic agents and they had reason to believe that he was carrying illegal drugs. Would that statement in and of itself make a detention? If I walk up to you and say, hey man, I'm a narcotic agent and I think you're carrying illegal drugs, can you not say, frankly, my dear, I don't give a damn what you think, I'm leaving, and try to walk away and make them either put hands on you or tell you you cannot leave? I still think you're free to leave. Now, the courts may say a lot of dumb, fearful, insecure people that don't understand the Constitution or law and who would never talk back to an officer may be intimidated. But you can't make laws on those little, every measly mouse. You know, that's like making laws for kindergarten. How hard is it to intimidate a kid in kindergarten? Shit, a cop just show up and they're pissing their pants. So, I mean, you can't make law on whatever. Supreme Court ruled contact illegal drugs. Similarly, in Wilson v. Superior Court, the California Supreme Court ruled that an ordinary citizen confronted by narcotics agents who has just told him that he has information that the citizen is carrying a large amount of drugs would not feel at liberty to simply walk away. Well, they ain't talk to me because I'm freaking leaving. I'm telling you, unless a cop tells me I can't leave, I'm walking. I'm gone, people. That is the best way in the world to make sure you don't get caught up into were you detained, were you not, was it voluntary, was it consensual, can they use your voluntary statements because you weren't detained. Once you're detained unlawfully, if you give a statement, you can get it suppressed because they shouldn't have had it. But once you hang around and you make it muddy, you lose that ability. In contrast, investigative questions are worded so to convey the idea that the officers are merely exploring the possibilities that the suspect might have committed a crime. While such questioning is potentially incriminating, it is also potentially exonerating. Aw, I'm just here to help you. I'm from the government. I'm just trying to help you prove you're innocent. Okay? I want to take this breath test and I want to pat you down to prove that you're not involved in this crime because I'm here to help. I want to exonerate you. Yeah, that's what police do. Perfect. While questioning a suspect potentially incriminating is also potential. In People v. Lopez, the court noted that while the officer's questions did indicate he suspected the defendant of something and that his questions were not the stuff of usual conversation among adult strangers, Somebody quickly, let's define, what is the stuff, usual conversation among adult strangers? Okay? This is how, when you don't read these cases, you have no idea where this court's coming from. Now, I know kind of what they're meaning. That, look, most people who are just talking when they're adults, they're talking about the weather, they're talking about sports, they're talking about where they're going, good food, what's happening, how you doing, nice to meet you, does your kid go to school, blah, 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 blah. You're not talking about crime, investigations, suspicion, etc. So that's kind of what I think they're trying to convey here. But we're back to his tone. His tone was apparently no different than those presumably gentleman qualities he displayed in the witness box. Aw, he was such a gentleman in the witness box. The jury just loved him. Miranda. Officers should never Mirandize a person whom they have contacted. Now let's just take that statement right there out of context by itself. Who thinks that's a great statement that you could be teaching a bunch of cops on the streets? Officers, according to the court, you should never Mirandize a person who you have contacted. Well, let's put it in context. This is because Miranda warnings are commonly given to people who have been arrested. Thus, a person who is told that anything he says may be used against him is likely to think he is not free to leave and he's being arrested or is arrested. In addition, as noted earlier, Miranda warning is superfluous. The hell does that mean? Hang on, people. Shit.
Superfluous.
Oh, superfluous. Oh, shit. Now that I've heard it, I know what it is. I've never seen it written down. Superfluous. Okay, that usually means like bullshit. Unnecessary, especially through being more than enough. Okay, I got it. Sorry. Some smart ass is going to be in the comment. I can't believe you didn't know what superfluous was, man. You don't know what you're talking about. Shut up. I'll block your ass if you come here acting like you're freaking Mr. Superfluous. All right. Because it is required only if the suspect reasonably believed he is under arrest. Mood of encounter. So we went from tone of encounter to mood. But Rick, the law says you can shoot somebody for carjacking. Do you see how things are looked at differently when you get into court and court cases, and how the judge rules and how things are viewed and questioned and considered? How the totality of circumstances are so varied that for someone to say, the law says I can shoot you for carjacking and I can just shoot you. I don't need to be fearful. The law says that I can do it and I'm protected. Well, give me a postcard when you're in jail. Let's see. Mood of encounter. So now we're into the mood. The manner in which the officer addressed the suspect responding to his questions and statements is pivotal because these are circumstances that the suspect could necessarily perceive has indicated the nature of the encounter. So, what we're saying here is, officers, when you're dealing with the pesky citizens, please be cordial, be nice, smile, keep your tone civil, talk nicely, even though you're about to shoot them, and saying, hey, motherfucker, I'm about to shoot you in the head. Make sure your tone and your mood maintains a certain decorum as not to put the suspect in fear he's being arrested or detained. Really? Questions statement pivotal. For example, U.S. versus Kim, the DEA agent approached two suspects for drug trafficking on an Amtrak train and said, you guys don't have drugs in your luggage today, do you? Wow, that's a good question. Wonder how they're going to answer that. That's like, when did you stop beating your wife? What? Who? What? Let's see. One of the men, Kim, then consented to a search of his luggage, which contained methamphetamine. Okay, Kim's a dumbass. Why did he consent to a search when it's drugs? Look, I can't tell you the number of people that consent to searches when they have drugs. They're hoping, they are so concerned about knowing that if I say no, the cop's going to know that I got drugs. So maybe on the off chance, in the 1 in 100,000 percentile, maybe the officer, if I say yes, will decide, one, not to search, or will be an incompetent buffoon and will search and miss my dope. So what odds do I want? The fact that I say no and he knows I have drugs, or the fact that he may miss it or may not search? I'll just go ahead and give him consent. That's the plan. That's a great plan. How'd that work out, Mr. Kim? Kim Jong Rocket Man. Let's see. Then consented to a search of his luggage when containing methamphetamine. And rejecting Kim's argument. Now Kim's arguing. He wasn't arguing when he gave consent. Kim's argument that the agent's questions regionally indicated that he was not free to terminate the encounter, and the court noted that the tone of the question in no way implied that the agent accused or believed that Kim had drugs in his possession. It was merely an inquiry. How many of you people think cops go around and just inquire whether you got drugs in your luggage for no other reason than just to inquire? Because inquiring mind wants to know. Who believes that? Raise your hand. Freaking dummies. In other cases, the courts have noted the following as indicators that an encounter remained consensual. The officers spoke in a polite, conversational tone. They were restrained. They were non-threatening in their appearance and demeanor. How can you be non-threatening in appearance when you got a damn badge in your Batman belt, taser, freaking pepper spray, baton, dog, electric freaking baton? I mean, shit. How can that be non-threatening in their... A freaking cop, even driving by in a freaking patrol car, is threatening to me. There's no telling when he's going to whip out his gun, say I'm in fear of my life, and start killing people. Rick, you can't say that. All cops are heroes. Okay. Let's see. Pose their questions in a calm, deliberate manner, and their voices were very quiet and subdued. Oh, you can tell I never had a problem. If they hadn't ever questioned my tone, it'd be like, yo, you big dummy, I don't like your tone. In contrast, in the case of People v. Spicer, here officers stopped a car driven by Mr. Spicer. Oh, poor Mr. Spicer. Out going to get a donut. Got interrupted by the cop. Because it appeared that he was under the influence of something. While one officer was conducting the field sobriety test, those commonly known as FSTs, another officer walked over to his passenger, Mrs. Spicer. Uh-oh, let's get Mama too. And asked her to produce a driver's license. Although he merely wanted to make sure that she could release the car to her, he did not explain this. While Mrs. Spicer was looking through her purse, the officer saw a gun. Why? Why was Mrs. Spicer looking through her purse with a gun in there? Because she was trying to be friendly. She was trying to cooperate. She was merely complying with the kind officer who just merely wanted to see her license so he could release the car. And now her ass is going to jail with Mr. Kim because she had a gun in her purse. And look, I've caught people in California. Nobody can carry a freaking gun. That's very rare that you see somebody with a concealed permit. And I caught many people with guns. And I rarely arrested them if they were what I call a righteous citizen. They had a job. They were going to work. They were coming from work. They had kids. They were a woman that wanted to protect themselves. I thought it was bullshit laws, and I didn't enforce it. So if you want to go back and go, man, you just pick and choose, you're right. I did pick and choose. I didn't write freaking tickets, and I didn't fuck with good people who had guns, and I didn't mess with bullshit marijuana when there was other people to crime and more violent crime that I could be dealing with. But I digress. Where the hell was I? Where's poor Mrs. Kim about to get her a life lesson from the officer friendly? While Mrs. Spencer was looking through her purse, the officer saw a gun and arrested her. Oh, I thought he was going to give her a break. I thought he was going to release the car to her. No, he arrested her. But he was her friend. He was going to release the car to her, Rick. We're told the cops are heroes. Whatever. But the court ruled the gun was seized illegally. Ooh, maybe the court got it right. Mainly because the officer's blunt attitude had effectively converted the encounter into a de facto detention, said the court. Had the officer made his purpose known to Mrs. Spicer, it would have substantially lessened the possibility of his conduct could reasonably have appeared to her that was coercive. So the court kind of gave her an iffy on this. Hey, she had a gun. She wasn't supposed to, but she's a woman. So she got her pussy pass. She went to court. Maybe it was a female judge, and they let her go. This normally doesn't happen, especially in California. I'm glad it did happen, and I'm glad they did lose it. I wish they would have, sanctioned the officer for doing it, but they won't. That's why cops don't care. See, people think, you know why cops don't learn this shit and don't waste time reading this? Because it doesn't matter. Even when they fuck it up, nobody cares. There's no law. None of this that I've read is law. None of this is going to get a cop arrested. None of this is going to get a cop to lose his job. Why should he learn it? Why should he try to apply with the current law and treat citizens fairly and follow the Constitution? There's no accountability. There's no repercussions. All right. I'm going to finish after this one because this is just going on forever. Detention, contacts. You guys can go read all this. I'm going to finish this page here. We're at 34 minutes. I'm getting hoarse. Not hoarse like writing Buddy and Mr. T. Hoarse like I can't talk. I'm glad Mrs. Spicer got her ass out of jail. She shouldn't open her damn purse and got her ID. She should have said, do I have to show you the ID? Why are you asking ID? Am I free to go? And then it would have been no-brainer. The gun would have been dismissed. She was lucky it was dismissed because the court looked out for her. Persistent questioning. Suspects who have agreed to answer questions from officers often will give answers non-responsive, vague. This sometimes ploy. Suspect tries to appear uncooperative while providing officers little or no information. Yeah, that's true. When this happens, officers must necessarily be persistent, although the persistence of these questions at some point indicate that the suspect is not free to leave, and that will... What's that damn car down at the end of my road? Sorry, I got distracted. Some cars have been on my road. Will ordinarily happen. For example, in U.S. v. Sullivan, U.S. Parks Police... Okay, park police, usually not real savvy on law and usually get a lot of bad case law because they screw shit up. Park police officer contacted Sullivan and said he had anything illegal in his vehicle. Sullivan hesitated, then asked, illegal? The officer repeated the question, but instead of answering it, Sullivan turned his head toward and looked straight ahead. Good for him, he didn't answer questions. The officer persisted, telling Sullivan that he had anything illegal in the vehicle. It's better to tell me now. Look, people, it ain't never better to give government evidence now or later or at any time in your freaking life. No matter what a cop tells you, how much better it's going to be, how you can help yourself, etc., unless you have an attorney with a signed deal from the DA giving you immunity or promising you will not go to jail, don't answer questions or talk to the freaking police. Come on, people. I'm trying to keep your ass out of jail. Even though I like postcards from people that watch me that end up in jail, I'd rather you not go to jail. Let's see. The officer persisted. It's better now. Still no response. Eventually, Sullivan admitted that he had a gun in the car. Oh, my God. Sullivan, you freaking big dummy. And admitted he had a gun in the car, which led to his conviction of possession of a firearm by a convicted felon. So this guy's a freaking felon. He's been in jail. He's been to prison. He's been arrested several times. He knows the freaking law. He almost had it right. He didn't answer. He didn't want to answer. He was on the right track. And then he broke down and told him he had a freaking gun in the car. Sullivan, you deserve to be in jail. Send me a postcard. In rejected Sullivan's argument that the officer's persistent questioning had converted the contact into an illegal detention, the repetition of questions interspersed with coaxing was prompted solely because Sullivan had not responded. Sullivan may have been enacting his Fifth Amendment rights to remain silent. Did the court consider that? Maybe that was his way of exerting his Fifth Amendment right. Courts didn't do that because Sullivan was already a prisoner and he's already a felon. So, and it was a gun. People usually don't get breaks on guns. They encouraged him to answer, but did not demand one. Oh, they encouraged, but they didn't demand. Oh, how nice. In contrast, Morgan, the court ruled that baseball star Joe Morgan, never heard of the dude. If he's a baseball star, I don't know why the hell I ain't never heard of him. I ain't heard of all stars, but if he was a real star, I think I'd heard of him. Who the hell's Joe Morgan? Was unlawfully seized at Los Angeles International Airport when LAPD narcotic officers continued to question him about Morgan, indicating in no uncertain terms that he did not want to be bothered. Said the court, we find that Morgan's unequivocal expression of his desire to be left alone demonstrated that the exchange between Morgan and the officer was not consensual. Oh, well, that's a good little ruling. So, because he protested that, leave me alone, I don't want to deal with you, I'm on my way, stop harassing me, stop questioning me, get out of my face, I'm leaving. All those, the court said, hey, it wasn't consensual. I agree with that. Warrant checks. Running a warrant check without suspect's consent will not automatically result in detention because the law presumes that the contacted suspects are not wanted for anything. Really? That's what the law presumes? Then why the hell are you pulling people over and asking them for shit? If the law presumed that you didn't have fucking anything to hide, why are they asking you if they can run you for fucking warrants and asking for ID? That's just flat out bullshit. But you can't say bullshit to the court. But
warrant checks can be problematic. That means you can step on your dick and get in problems because it takes time to get the information. And during that time, the suspect might reasonably believe that he's not free to leave. For example, a detention will likely result if the officers, without the suspect's consent, took his ID to the patrol car. We already went over that, didn't we? As in California Supreme Court explained, a warrant check does not constitute a decision per se, but detaining a person without cause until a warrant check is completed is illegal. For example, U.S. Jones court ruled that Jones was illegally detained when the officer took his license and proceeded to conduct a records check. In contrast, the court in Arizona ruled, or not Arizona, U.S. v. Anilla, ruled that the detention did not result when the officer, instead of taking the suspect's license patrol car, stood beside the patrol car near where the suspect was standing. Consequently, if the officer wanted to run a warrant, there should ordinarily seek the suspect consent. None that the same rules would seemingly apply if the officers held onto the suspect's ID. Seeking consent to search, like any other request, a request to search. All right, consent to transport, detentions into contacts. Let's see. This might be good. We're 41 minutes. In the course of a detention, officers may conclude that although they do not have suspicions along time grounds, at some point the detention must, of course, be terminated. Nevertheless, they may be able to continue to question the suspect that he is now free to leave. So, detentions into contacts. This is the reverse. Instead of making a contact into detention, now we're going to say, you're detained, I got your driver's license, you're lawfully detained, now I'm finished with you. Now I'm going to give you your license back and tell you you're free to go, but I can still question you. And now it's consensual. I'm not sure why you'd want to do that. Return of ID. If the officer is in possession of ID from the property, they must return it. You're free to go. Means you're not detained anymore. No contrary circumstances. There must not have been a circumstance that, despite the free to go advisory, would have reasonably indicated that the suspect that he was, in fact, not free to leave. For example, U.S. v. Beck, the court ruled the suspect was detained because although he was told he was free to go, he was also told he could not leave unless he consented to search. All right, shit, this is part 4. I'm Horace. Hopefully you got a little bit better understanding about contacts. This is a great publication. If you want to pull it up, it's great reading material while you're sitting on your throne or wherever. It'll keep you up to date with laws, how the courts are ruling, how cops are making mistakes, how cops make bad case law, good case law. Any cop working should be reading this every quarter. It's one book, 24 pages, once a quarter, people. That's less than a page a day. Read the damn book. Your knowledge of the courts and legal process will be greatly enhanced by reading this. All right? Well, in that there, y'all have a good one.